Matter of Cologne v. Teachers Retirement System. Counsel.
Good afternoon, Your Honors, and may it please the Court. My name is Kirsten Miller on behalf of Petitioner Anne-Marie Cologne. I would like to reserve 5 minutes for rebuttal, please.
Yes.
A ruling in favor of Petitioner will ensure that the hundreds of thousands of members of New York's public retirement system can have confidence to know that their beneficiary designations will be honored after their death. This Court should reverse the First Department's ruling for 3 reasons. First, it is unconstitutional because it retroactively impaired members' rights to choose their own beneficiary.
So, counsel, let's stop first on the constitutional issue. If we were to agree with you, what would the effect of that ruling be? Would we be declaring the statute unconstitutional? What would we be doing?
Well, Your Honor, if you were to agree with me, part of our argument is that it was unconstitutional specifically because it applied retroactively after Mr. Barcelo had already died. And so there is an opportunity for this Court to recognize the very important...
So who would it affect? Who would our ruling affect? What class of people would it affect? How far-reaching would it be?
Well, if you were to rule on the fact that it impaired Ms. Cologne's vested rights that were already vested to her at the time the law went into effect, again, it would only affect that very narrow group of people who were the designated beneficiaries at the time that someone died, and then a law went into effect after their death that retroactively took away those benefits from them.
Is it that it took away the benefits, or it changed the bar for accidental recovery? And the accidental recovery beneficiaries were statutory. They were different, correct?
That is correct. There had always been...
So before he died, there was a specified group of people who could collect if he was deemed to have died accidentally, correct?
That is correct, Your Honor.
Did that change with the law?
Your Honor, in our view, it did change with the law because prior to the amended law, accidental death benefits had only been paid in a very narrow set of circumstances in which there was always a causal connection between the job and the death. And what this law did for the very first time was to sever that causal connection so that it says that all deaths from COVID, there is going to be an irrebuttable presumption.
But before they changed the law, beneficiaries who could recover were a specific category of people. So the beneficiary knew if he died, if it's deemed accidental, those are always the same people, right?
That is correct. It was always the same people, but I think it's important to recognize that members have the right to make plans, and they make plans based on calculated risks. And so
But accidental you don't plan for normally, right?
Well, as a teacher, I think people do generally have an idea of whether a sedentary job is expected to have, a sudden, unexpected event.
Well, could he not have planned and made sure she was one of those specified persons to be covered by accidental?
I think people make plans based on their expectations of what the level of risk is. And what this job did was it took what I think was a very low level of risk for a teacher and turned it into a very high level of risk because there's now an irrebuttable presumption that all deaths from COVID are automatically going to be deemed to be...
Is this still your constitutional argument? Are you saying it was unconstitutional to expand the number of cases that qualify as accidental death?
We're saying that this is the first time that the law radically changed what it means to have an in-service accident. So he always knew that there was a chance if he had an in-service accident that the benefits would go to his statutory beneficiaries.
But doesn't that really go to, there's a risk you just can't quantify in a way because nobody expected this. I mean, this is a, please God, once in 100-year episode, and all they did was react to that by putting this law in place that says if you were there within 45 days, right, it's an accidental death. So what could you do then in response to something like that? Their hands are just tied?
Well, I'm not sure I'm following. What could you do?
Yeah, what would the legislature do? They were reacting to this once-in-a-100-century event, and they said, okay, we're going to define this way, to provide these benefits, and now you're saying that was unconstitutional.
There are other ways that the legislature could protect these
Sure.
people if they wanted to protect them that way. I think it's very important to remember that these benefits are part of a member's deferred wage.
It
So
seems, it seems to me that if we accept your argument, then there can never be a change to what constitutes an accidental death. Because if the members are making a calculated assessment between their designated beneficiary for regular death and their statutory beneficiary for accidental death, if the legislature at any point changes the definition of accidental, everyone's expectations have been thrown off, so they're stuck. They can't change the law. Is that what you're saying?
That's not what we're saying. We're saying that the legislator should have made a rebuttable presumption, just as it did with all other circumstances in which it made it easier to access the accidental death benefits. So for example, in the World Trade Center cases, it created a rebuttable presumption. The World Trade Center cases are similar to COVID in the sense that these are things that are difficult to trace. The injuries could be things like cancer or
I
depression.
thought you had a much more narrow argument, and I thought that's what a member of the bench had asked you to begin with. I thought this was a problem, in your view, because the teacher passes away from COVID, and then the law is passed and made retro. So the teacher had no warning. It's not like the teacher was alive when they passed the statute and could then say, I better plan for this in case this looks like it might affect me. This might change, who's going to get these benefits, and I want to make sure I take care of her. I thought that you were focusing on that group, which may be quite a small
That-
group, I don't know. I'll ask and see if we know what these numbers are, unless you know what these numbers might be.
Your Honor, that is our argument as well, that was a second reason, in our view, why it was retroactively impaired, because at the date of the death, the benefits were already due to the designated beneficiary. And then 6 weeks later...
But isn't that really a vesting argument as opposed to an argument about the scope of the impairment clause and whether this is in the face of that?
Well, Your Honor, in Cook, this court said that benefits vest upon the occurrence of retirement or death. So again, it's our view that the benefits vested, and then the beneficiary, the member, had no opportunity to make changes, to make alternative plans.
I take it you have a vested argument, but how does that line up with your argument about the scope of the pension impairment clause? I thought you were arguing that that would apply whether or not the member had passed away before the amendment or not. Am I misunderstanding that?
We have two separate arguments, Your Honor. The first is that any change that impairs a member's right to choose his or her own beneficiary violates the pension impairment clause.
Whether that change is made while the member is still alive or after the member has passed away, yes?
Yes, that's correct. But of course, it is especially acute in circumstances where the member has already passed away and
Well,
can't
it can't possibly be once they've passed away. I thought this argument was about their choice in planning.
I'm sorry, it was about their
I thought
choice.
this argument was about the member's choice in planning. It has to be during their lifetime. Are you suggesting the estate has some right here? Now I'm confused.
No, the argument is regarding the planning. And in Lippman, this court said that people need to be able to look forward to their pension benefits, that they understand the stability, they understand who they're going to. And certainly if a law is passed 6 weeks after someone has died, that person can no longer make any changes. He has no understanding that this law could go into effect.
But no amount of planning would have changed the statutory beneficiaries, right?
No, the statutory beneficiaries are who they are. That's
Right.
correct. There's no changing that, but at the same
And you can't
time,
plan the circumstances of your death, correct?
that is correct. But if this law had gone into effect at the time that he was still alive, He likely could have married her.
But he could have married her before so that she would have been always a statutory beneficiary. Could he not?
He could have, but again, it goes back to
So
the
then she would
calculated.
be covered under either category of beneficiaries.
Of course, but Your Honor, in my view, it goes back to the calculated risk. If he had known that there was
So
this.
you are saying, I'm sorry, I'm misunderstanding. I thought in response to, I think Judge Halligan's question, you said you didn't think they could make this change even if the beneficiary, even if the person was still alive who could make the change. Is that your position or not your position?
Yes, that is our position. But again, the second argument is that this was especially an impairment after the person had already died to make a law change that was retroactive after their death.
I'm not sure I understand that. I mean, it seems to me that either something offends the pension impairment clause or it doesn't. And setting aside whether the right had vested, which I don't think is a constitutional argument, maybe I'm misunderstanding it, but I think it's an argument about whether he has the rights or not. Why does it matter in terms of the constitutional analysis whether the member is still alive or has passed away? Doesn't it either impair a right that you have under the clause or not?
I go back to the planning and I go back to the risk, and I think that both of those are important.
But where in the clause do we take that kind of distinction? I mean, are you arguing that we could hold that the pension impairment clause is violated as it applies only to members who had passed away in that window, right? Who are covered but passed away prior to the enactment of the statute, but that it doesn't apply as to anyone still living at the time of the enactment of the statute? And if so, what would the reasoning be there?
I think that you could, and the reasoning is that going forward, people know what to expect. They would know automatically that their beneficiary.
But if that's right, I wonder whether that almost proves too much, because if that's correct and impairment turns on whether you have notice, then it seems like that would actually dilute the force of the cause, right? Because you could say, well, we're going to reduce your benefits or change who the eligible beneficiaries are, but because we're giving you notice and you can plan your financial affairs accordingly, it doesn't violate the clause. I would think that maybe it doesn't matter whether they're alive or have passed away.
But certainly, once they've passed away, they can't do that. And he would have no reason to expect that something that was entirely unrelated to work could now all of a sudden be deemed to be an in-service
But they
accident.
could never control how they were going to die
But at
in
the
any
same,
event.
that's correct, but the more you expand this, if all of a sudden the legislature starts to say, all deaths from cancer, all deaths from heart disease, no matter the connection to work, now we've expanded this to the point where designating someone as a beneficiary is just an illusion.
Well, isn't it the case that there are a lot of disputes about whether a particular death is accidental or is not? I mean, I've seen court cases about that, and sometimes you don't know which way they're going to come out.
There are, yes, Your Honor, there are many
And so
disputes.
it's a little hard to predict that. I mean, I don't think you would say that if a court decision came out a different way than what the decedent had expected, it was unconstitutional.
No, we're not saying that just because it went a different way than the decedent expected, it was unconstitutional, but we're saying that people have a right to make plans to take care of their loved ones, and they have a right to expect that the legislature is going to keep their benefits in place under the same terms and conditions as when they joined the system. And this radically changed the circumstances in which their benefits would go to a statutory beneficiary instead of their designated.
Thank you.
Thank you.
May it please the court. My name is Jamison Davies for the respondent, Teachers Retirement System in the City of New York. This court should affirm the First Department's unanimous decision. The law provides that if a member who reported to work in person contracted...
So do you know, I'm sorry, over here. You heard me ask before, maybe you'll recall. Do you have a sense of how many people, how many members, who are now deceased obviously, would fall into this category where they pass away, the law then gets passed, and then the law, of course, applies retroactively, and so the person who's passed away is now part of the coverage of the amendment?
Sure. I don't have a specific number. I don't think it's a very broad category of individuals because you'd have to have passed away in a very narrow
Yes,
sort of time
yes.
frame.
And passed away from COVID.
Correct, Your Honor.
It's the first 2 months of the epidemic, though, right?
Yeah, it was passed on the end of May 30th, and retroactive to March 1st.
Right, so it's 3 months, but really, and busy months, unfortunately, for COVID. Right?
Yes, and when it was very difficult to establish whether or not someone, might have contracted COVID on the job, that's part of the reason that the legislature was
But the group
removing
is
this.
even potentially smaller, right? Because it would have to be someone who didn't pick one of the statutory beneficiaries.
I'm sorry,
It would have to be someone who didn't pick the statutory beneficiary,
correct.
like in this case.
Yes, in many cases.
So it's even a smaller group.
In many
because
cases,
some
it
people
would be
may
the same.
choose the same person, right?
Yes, in many cases, the statutory and designated beneficiaries are the same person, probably in most cases.
Do
you think
do you
that
have a sense of that number? How many cases involve a different designated beneficiary and statutory beneficiary?
I don't have any statistics. I think from what I understand from TRS that it's often the same person or it's within the same sort of family unit, but I don't have a specific
I mean,
number.
are there other challenges pending?
Not that I'm aware of.
Do
So,
you think that beneficiaries have independent rights under the pension impairment clause, or do they flow only from the members' rights?
The rights of the beneficiaries flow only from the members' rights, Your Honor. I wanted to point out the case Cook that they're citing. The rights are vested in the member at the time of death or at the time of retirement. There may be rights that flow from that to a particular beneficiary, but the rights go to the member. It's the person who is a member of the retirement system who is protected by the pension impairment clause.
And have the members' benefits been impaired here?
No, they haven't. If they've been increased here because it's undisputed that accidental benefits are
but isn't the question whether the right to designate the beneficiary is protected? I mean, the clause says that membership in the system shall be a contractual relationship, and you can't impair the benefits of the contractual relationship. So as a general matter, I would think if you have a contract, right, and the contract's, A promises B that A will give C $10, right? The notion that A can unilaterally change who then gets that benefit, is it C or is it somebody else? I would think that that's an enforceable benefit of that contract. So why not so here?
The reason it's not so here is because, in fact, the way it works is that as the time he entered into the contract, there were already the statutory and designated beneficiaries. So really what the contract said when he entered into it is that in some circumstances I'll pay B, and in some circumstances I'll pay C. And there was the potential for litigation. TRS has acknowledged that they had not made a determination over whether or not some of these deaths could be ruled accidental.
Okay, so if it's a clarification of accidental death, I take your point, but do you agree that aside from that, could for example, the legislature pass a statute that changes who counts as a statutory beneficiary and apply that to members already in the system?
I think if you were to alter the priority or add a new statutory beneficiary in the list, I think that would be, a much more difficult question. I think that's not what is presented here.
So you at least agree that the question of whether the right to designate is covered, you'd say maybe it's a harder question than what we have here. But you're
Well-
not saying it's clearly unprotected.
Well, I would say that in that circumstance, in your hypothetical, it's actually, I don't think it's the right to designate. You'd be altering the statutory list, which those are not designated beneficiaries to start with. No cases have held that the right to designate a beneficiary is one of the rights that's protected by the pension impairment clause. There are statutory provisions that allow you to designate a beneficiary.
What about changes to the statutory beneficiary list? So for example, if there was a decision made to amend the statute to put domestic partners somewhere on the statutory beneficiary list. Does that implicate impairment clause concerns?
I think that would be a case that would much more directly implicate those kinds of concerns. I don't want to speculate as to how that would come out, but I think that would be a much closer case than what we have here, because you'd be inserting people who were not on the list at the time the member joined the system. And the cases all say that you have to look at what the contractual relationship was when the member joined the system. Here, when he joined the system, there was already this statutory list in place. The plan materials are in the record that were provided to him. They explain in some circumstances.
So if domestic partners had been added to the list around the time that this accidental death definition was changed, the litigants in this case would be on the opposite side of the V?
That's possible, or it's possible that someone who was on the statutory list in a different priority might be the person who's bringing the claim.
So with respect to the change here, did it do anything more than change the burden of proof required to establish the accidental death?
We contend that it did not. It basically, as with many other laws in the past, lowered the burden of proof, where proving causation of an on-the-job injury is difficult, and made it so that members could more easily access enhanced accidental death benefits the same way the World Trade Center bills and the HART bills do. It's both broader and narrower than those bills, and in some respects, it's a much narrower time frame. It's broader in that there is no opportunity for the TRS to dispute whether or not it was accidental, assuming the statutory factors are satisfied. I would like to point out that, my friend talks about it being unrebuttable, but there is no case, they pointed to no case, and we are not aware of any case where beneficiaries basically go in and have an opportunity to rebut whether a death is accidental or not. That happens in the context of litigation, usually against the retirement system, where it is ruled that a disability or a death is not accidental, and someone brings a claim to try to get the enhanced accidental death benefits. And this court has seen a lot of those cases. I would also point out that, it's not, there was always an
So
open...
just to be clear before you move on to whatever the other point is, your position is that it does not vest until all the documents have been submitted and approved and the check is cut?
Correct. That's when the beneficiary has some right. Until then, there's a right in the member, certainly. And one of the
The
rights...
member's deceased.
Right, but
Are you
then,
saying it's then a right that the estate has?
it can in some circumstances
And
go
the
to the...
beneficiary has some kind of springing right to whatever the estate is holding?
I don't know if I would describe it exactly in that way, but I think that is fundamentally right. I think until the claim is processed, I don't know if vesting even really works kind of here as a conceptual framework. Until the claim is processed by TRS, or TRS receives a claim, there's no right that exists.
And so can you be stopped? I think that's sort of the argument that's being made about sending the letters to the wrong address over and over.
Right. I don't think they haven't raised directly a claim of estoppel, and I think for good reason. Estoppel against the government is a very difficult claim to make. Their argument is basically based on the fact that the letters say due, that there's some amount due, but if you look closely at the letters, they say the claims can take from weeks to months to process. So even if I think it's about 4 weeks of time between when the letters were sent to the wrong address and
Would
when they were
that
received.
process mean how long it takes for the government to actually cut the check as opposed to making a determination that indeed the money is due?
I think there's an element of both. There was more documentation that needed to be received from...
What was missing?
There was, I think, the distribution instructions were missing. There may have been some other documents that needed to be processed.
Distribution sounds like you're owed the money, tell us where to send the check.
Yes, but the claim, what's important is the claim, there was no claim. If you look at the document specifically, they said that there was a claim that she needs to file. There was not a full claim at that point. And the statute is clear. Once it was passed, it says the benefits shall go to the statutory beneficiary.
Am I correct at some point that the daughter's, I think it was guardian, made clear that he or she planned to file a claim, but was waiting for whatever, I assume with regard to the guardianship status, to be confirmed to do that?
Correct, and the claim was filed shortly thereafter, I believe in the end of July of 2020, on behalf of the daughter. It had to be filed by her mother because she was still a minor at that point.
Did Ms. Colon receive some other benefits?
Yes, I believe she received approximately $600,000 from his other account, his tax-deferred annuity account. I just want to make one other point on the vesting point, which is that when the member dies, there is an argument that the statutory and designated beneficiary have some right. I think you can't say it's vested until there's a determination made as to who is the money is ultimately going to go to. Otherwise, it would just be a matter of who's first to file, essentially. And that is completely anathema to the orderly functioning of the teacher's retirement system. It also violates the provision of the law 607-1D, which gives the system the right to make the rules and regulations to administer the benefit.
Could you address what I understood the statutory argument, or at least this part of it, to be that the amendment anticipated this kind of circumstance, and therefore she is entitled to money, given that the way she's reading it, of course, that the statute and the legislature anticipated this and provided for someone like her? Can you address why, of course, from your perspective, that's an incorrect interpretation of the amendment?
Sure. There are several reasons. That's a reference to 607-1B, which basically says if an amount, and it reflects the fact that the statute's retroactive, if an amount had already been paid, you can't claw that back. It just means that the accidental benefit is reduced. But that's only, I think the legislative history makes clear that's only if it had already been paid, and also the statutory text and context make it clear, because in other parts of the statute, it refers to claims paid or payable. In that section, it refers only to claims paid. They don't address this statutory argument at all in their reply brief. The legislature uses those terms advisedly, and I think if it's using paid in one instance and paid or payable in another instance, that has significance. It also refers to the recipient as opposed to the beneficiary in other parts of the statute. So the recipient, which means someone who has already received the money, versus the beneficiary, which is someone who has a future entitlement to money. So I think the legislative history, the text, and the context all make clear that that provision was only intended to cover if someone had already been paid before the law had gone into effect. Unless the court has any other further questions, I'd urge affirmance.
Thank you.
Thank you, Your Honors.
Counsel, I'm sorry, before you start, I'd just like to go back to an original question I asked you. And so if we assume, let's say it's a small group, 100 people who died in this period and who have inconsistent beneficiaries, let's call it, and we were to find for you on constitutional statutory grounds, and it affects that group, what would happen in those instances? Would that automatically then be payable to, let's say, beneficiary A in every case of those 100?
Yes, it would be payable to the designated beneficiary, but I think you can also
But
read.
what if the person who was making that calculation really wanted it that way and thought, you know, if I do have some kind of accidental death, I want it to go to my minor child, but if it's a non-accidental death, because I'm pretty healthy and I don't think anything's going to really happen to me, I'm going to designate my partner, and that'll be a nice, you know, thing longer term, and it's good for my relationship, but accidental, if I die suddenly really like that, I want my minor spouse to have it. If we do this, that gets undone in every case.
Well, I think if people are concerned about dying in an accident, and this court has made it clear there's no opportunity to, figure out whether you will or you won't, then the person would have designated their child, their spouse.
But they did designate them. Like, so B designated to B is accidental. A is partner, right? Let's do it that way. And they're inconsistent beneficiaries. They changed the law. It's one of the 100 that have that. In every case, it goes to beneficiary A now.
Again, if they were concerned about dying from an accident, then they should have designated the statutory beneficiary to also be their designated beneficiary. They can make that choice.
But I made the calculation. I think, if it's an accident, I want my minor child to have this. It's sudden. Yeah, it could happen. It's a risk. Mm-hmm. The other risk to me is not so great. I have a partner, I'll designate that partner, and that's the way I want it. And that calculation would include some once-in-a-lifetime pandemic. If that happens, I would want my minor child to have it. But now, if we rule for you, that choice is wiped out, right?
Well, I think it's very difficult to start to get into the mind of the members in each case. But at the same time, if they were so concerned about that, they always could have designated that person they were concerned about, because an accident can happen.
Or they could have had an insurance policy, right?
That's correct. And again, that's what the Supreme Court recognized,
There was
was
an
that
insurance policy here, right?
That's not in the record. It's unclear, and I'm not able to argue things outside of the record, Your Honor. But certainly, the child is protected in other statutes as well. There's Social Security benefits that go to children. There's the estate that goes to children's. There's other ways that children are protected.
But I think the point is, you can't say that that wasn't financial planning on their part. When they said, okay, I recognize that this is going to go to my statutory beneficiary, and here I'm going to designate someone else. I think that's Judge Garcia's point, that that is financial planning for them. So, and your client could have done the same thing. Like, we can't just upend that because now the person that you think should have gotten the money wasn't a statutory beneficiary. Like, you can't say that what happened before, other people hadn't planned specifically for this contingency. If I die accidentally, this person gets it, I understand that, it's a statutory beneficiary, and this is what I'm going to do financial planning for everyone else.
Well, he never expected that at any point that an accident, an in-service accident, would be something that's not even connected to his job.
I don't think anybody expects it. That's the point. I don't think anyone expects that they're going to be a victim of an accidental death on the job.
But at the same time, can we just say anything is an in-service accident at this point? Because that's what the legislature could do. It could say anything is now an in-service accident, even if it's not
You'd have to have
connected.
a rational basis there, right? No? I mean, that could be reviewed. If any legislation that's passed can be reviewed for rational basis.
And there's not really any indication here, I think, that this was something other than an effort to, ease the burden of proof, because given the way COVID was transmitted, it would be exceedingly difficult, I would think, to prove that you were exposed at work as opposed to any place else. I mean, this does not seem like the sort of circumstance that you're posing.
I think a good example is if the CDC says that there's
Continue.
May I
Go
continue?
ahead, finish your answer, yes.
If the CDC says that there's a 14-day incubation period for COVID, this still requires us to accept a fiction that there could be a 45-day incubation period. So it's not at all connected to the work, even if there's scientific evidence grounding that.
Thank you.
Thank you.